Hi, good evening, everyone, and welcome to the BicTok 31st session. And for today's session, which is titled Delay and Damages, Claims in Construction Contracts, Effective Resolution of Disputes. My name is Michelle Wong, not Marshall as indicated on the screen because I'm using a separate device, and I'll be your host for today's session. So before we begin, let me run through a few housekeeping matters. So firstly, kindly ensure that the username reflects the name under which you registered. This will allow us to accurately mark your attendance and, where applicable, to issue your certificate of participation and your CPD points. Secondly, if you have any questions during the session, please feel free to leave them in the chat box. And alternatively, you may also raise your questions during the Q&A session at the end, where you will have the opportunity to voice them out directly. And thirdly, keep your microphones muted throughout the session so we can ensure that everything goes smoothly today. And now it is my pleasure to introduce our moderator and panelists for today. Our moderator is Mr. Qin Yuan Feng. Mr. Qin is a fellow of the Chartered Institute of Arbitrators. He is a distinguished arbitrator, accredited mediator at AIAC, and adjudicator under CIPA. He also serves on international panels of arbitrators in Taiwan and Hainan, with expertise across arbitration, adjudication, mediation, family law, and construction law. And joining us as panelists are, firstly, Ms. Victoria Loy. She is a partner at Shook Lin and Bock, Kuala Lumpur, specializing in construction, engineering, arbitration, general litigation. She is recognized by Chambers and Partners in the practice area for construction for 3 years in a row, as well as ranking as Future Star by Benchmark Litigation Asia Pacific. Secondly, we also have Mr. Balan Nair. He's an experienced litigation and arbitration lawyer with a master's in international arbitration and construction law from Queen Mary University, London. He also has extensive experience in construction, energy, and engineering disputes. Thirdly, we have Ms. Esther Chow. She is the head of legal at Kone, Malaysia. She's also a CIPA adjudicator and a BICM arbitrator. She is also a fellow of the Chartered Governance Institute UK and Ireland, and also the fellow of the Malaysian Institute of Chartered Secretaries and Administrators. And we are honored to have such an experienced panel with us today. So without further ado, I will now hand over the session to our moderator, Mr. Qin Yuan Feng.
Thank you, Michelle, for the introduction. Welcome, everybody, to this BicTok session number 31. Thank you for taking your time off to join us. Now, I think I will dive straight into it so as not to waste any time. As you know from the introduction, that the topic today is about resolutions of disputes in respect of delay and damages in construction contracts. So I would like to ask firstly, Ms. Esther, having previously been in private practice and now an in-house legal advisor, can you tell us from your experience, what sort of terms and conditions do contracting parties need to negotiate prior to signing a construction contract?
Yeah, thank you, Mr. Chin, on the brief introduction. So now, as the head of legal for Kone Malaysia, in the capacity of a subcontractor, I have listed down at least 6 items that we need to give consideration or need to give attention when we review the LOA. The first thing is to look for the LAD clause. Whether the LAD clause is very clear. Usually you'll be expecting they would give you a certain amount of the daily rate of the LAD. And then if there's a percentage of the contract sum or daily rate, then I'll always advise the company to insert a cap, LAD cap. For example, 100% of the contract sum, 10% or 5%, really up to the party's bargaining power. The second thing is that the LAD amount must be clear. Say you have a situation where they say you are subject to LAD, but what does it mean? Where is the amount? What is the daily rate? And then when you look at the LAD amount, the second thing you need to think about it is whether it is proportionate to the contract sum. Say it is like you are getting a 600,000 job where your daily rate could be like 50,000 to 100,000. So it also means that it's not reasonable. Then you got to bring it up and negotiate with your employer or main contractor. Third one is the most important thing, contract duration. Is it doable and reasonable? Whether it takes 100 days, 10 days, 5 days to carry out a package, main contract work or subcontract works. That's the thing that the engineer or the architect or the consultant would know. If the contract duration is not reasonable, I think the whole contract is impossible to be carried out. Then you will subject to a lot of legal dispute later. It doesn't do well for the project. So please check whether the contract duration is reasonable and feasible. Fourth one, contract sum. In Malaysia construction industry, I think most parties here are more comfortable if the LOA is regulated or governed by a certain commonly used contract form. So here in Malaysia, we have PAM form, like 80% or 90% used by the industry. FIDIC will be used by the international companies. I'm quite happy with FIDIC because it offers you a 10% LAD cap. We have IEM form, AISC form, and PWD form. These are almost fair to two parties, maybe 60-40 or at least 50-50 to two parties. If you know the contract well, then you will know what's your rights and obligation. Why using a contract form is very important. First of all, parties are very familiar with the EOT procedures, claim procedures, prolongation cost procedures in a contract. With familiarity, parties can negotiate and manage the contract better. That's why when I get an LOA, I would insist on a commonly used contract form. Yeah, having a bad contract form is better than having no contract form. Fifth one, reasonable approved work program. This is your staff, engineers, consultant. You must know your work program very well. If you do not have a work program, you do not know your critical path, I think even the lawyer couldn't help you well sometimes. Six things is a BG. Bank guarantee is important for you to evaluate situation. Why I say that? Because the start date and the end date you know. Say, for example, you receive an LAD claim from the employer or main contractor, and then the other side, they threaten to call your BG. So it's very important to know what's the amount of BG and what's the expiry date. It may be expired, then it will change your bargaining power, it shifts your negotiation process, how you want to do a situation. Last but not least, I want to end with still the federal court decision, cubic decision. You need to have this in mind. Employer is no longer required to prove the LAD amount suffered. Is for the contractors, subcontractors, main contractors to establish that the LAD imposed is not reasonable. Yeah, that's all from my side. Thank you. Pass back to you, Mr. Chin.
Okay. Before I go on to the next question, contract documents which you mentioned just now, the PAM form. Is there room for parties to negotiate some of the terms and conditions there from the standard form?
Yes, there's room for negotiation. Negotiation should be initiated by any parties. If you never try, you never know. PAM doesn't have an LD cap, but you can always insert it in your LOA. LOA take precedence of all other contract forms and work program and whatnot. So never give up to get a nice LD cap. You cannot get 10%, but try to go for 100%. Then you know your risk well.
Okay, all right. Now, I would like to pose the next question to Ms. Victoria. As a legal practitioner, can you tell us some of the problems or issues which contracting parties may encounter during the contract implementation stage?
Yes, happy to. I've actually prepared some slides, but so I'm not sure whether you can see them now. Can you see them?
Yes, I can see it.
Okay, all right. So now what Esther had just elaborated upon just now was before the contract was entered into the negotiation stage. So now, of course, what next after the contract has been entered into? Now, I think this was also covered by Esther just now. Be familiar with the contract, and I would say that this is. I would also stress that this is quite important because as a dispute lawyer, we come across many situations where we ask our the clients or even sometimes the representatives, okay, so why was this clause not actually followed? And then they say, oh, we didn't we did not, either we did not realize, or we thought that the other side would not be insisting on it and all that. So but the first thing I would say is, once the contract is entered into, or even maybe before the contract is entered into, you should actually be familiar with the contract, so at the outside what are your rights, what are your obligations, what are the procedures to be followed, what are the documents that you need to keep records of. So I will then go on to the next part, which is keeping proper records. A lot of times also reflecting on my experience as a disputes lawyer. We ask for documents, for example, minutes of meetings, and then sometimes we find that, the minutes are either have been missing, or you only have some, you don't have some, or there were no minutes at all to be found. So, and that or a lot of things in the project were actually done verbally. So that can be a problem, because that's also where disputes happen, because no, you said this, no, I said that, and that there's no proper records to actually no contemporaneous records to actually show what was discussed or what was agreed. Now, then I move on to the third point that I have on my slide, which is to comply with the contract. So be familiar with the contract so that then you can actually comply with the contract. And the clauses are there, for a purpose. There are processes in there. There are procedures to be followed. So follow them as much as possible, because that may actually, determine whether you are entitled to something or not. And then the fourth point I would like to make is that it is actually important to properly manage and oversee the contract. So in fact, I would say have someone or even have a team to actually make sure that the timelines are followed, the procedures are complied with, and overall even the letters, correspondence are actually replied to. So now I move on to, okay, why did I raise all the earlier points? Essentially, it is actually to minimize uncertainties and disputes. If you follow everyone, I mean, ideally, if everyone follows the contract, then you kind of know what is going to come next. But if parties start not following the contract, you sort of cut corners here, you are lax there, the other party will not know what to expect. And after a while, nobody is really following the contract. And then, when disagreements happen later on, we are not quite sure, okay, so are we going to look at the contract strictly, or is there going to be room for argument on the facts and things like estoppel and waiver and all? It'll add to it, because there arises uncertainty as to how would the parties' rights and obligations be ultimately determined. Now,
Victoria, sorry to
Yes.
cut in, but I think
Sure.
the participants cannot see your slides.
Oh, all right.
Yeah.
Strange. Maybe
At the moment, we only can see the first slide, I think.
Oh, okay. All right. I've actually changed, moved on already. Like maybe what I can do is, let me just try and see whether maybe in what I can propose is this. To save time, because I understand we don't have a lot of time, perhaps I can share the slides later on. Would that be okay, Mr. Chin?
Yes,
Okay.
that'll be fine. Thanks.
All right. Okay. So I was just saying that talking about the importance of actually complying with the contract, and a lot of it is also to actually for the parties. It's good for the parties actually to follow the contract, because many a time it actually preserves the rights and entitlements that the parties have. In particular, because we are here, we're talking about delay and damages. So there are a lot of delay and damages provisions that are, and the procedure especially, that is mandatory in nature. If you don't follow it, you may not be entitled to, for example, obtain extension of time. So I'll just move on to give some examples. So Esther mentioned just now the PWD form as well as the PAM form. So for those who may want to read further and all that, I mean, in the PWD form, the 203A form, which is the government and main contractor form. So there are clause 40.0 talks about the damages for non-completion, and here the government can only recover LAD after the issuance of a CNC. Clause 43.0, delay and extension of time, employing the phrase shall, denotes mandatoriness. Clause 44 also claims for loss and expense. If the contractor fails to comply with the notice provision, he shall not be entitled to such claim, and the government shall be discharged from all liability in connection with the claim. So what I just want to stress here is that looking at the language that is used in the contract denotes that certain steps are actually mandatory, and if you do not follow it, the court may very well hold that you're not entitled to that particular claim. So and the PAM contract also has similar provisions. Take, for example, clause 23 on the extension of time, which actually provides for a two-stage process. By a certain time, there must be a written notice of the intention of applying for an extension of time, and it is actually expressly stated to be a condition precedent to entitlement to extension of time. And then the next step would be to submit particulars about the extension of time. And if the contractor fails to submit such particulars within the stated time, then it is deemed that the contractor has assessed that such delay events will not actually delay the completion of works. So those are just some examples I'd like to highlight of terms that have to be followed. If not, then a contractor may actually lose the right to claim for, or rather ask for extension of time. Now, I'll try and cut this short. I just wanted to highlight two cases. One is actually quite a recent decision. MS Elevators Engineering, Sdn Bhd, and Fairview International School, Nusa Jaya. Now, 2025 Court of Appeal. I'm not sure whether it's gone up further on appeal, but anyway, the court in this case had to deal with clause 23.0 of the PAM contract 2006, which is essentially the clause on extension of time, and the process where, the two-stage process I mentioned just now. And the Court of Appeal held that, here the defendant had said that, there were certain delay events, and therefore, LAD should not be imposed on the defendant. But then the court found that, they did not actually apply for any extension of time. Pursuant to clause 23.0. So no notice was given, no substantiation was given. So the Court of Appeal held that the defendant or the appellant here cannot now turn around and blame the plaintiff respondent for any unwarranted delay, because no application was actually made in the first place. Now, in fact, this case, MS Elevator Engineering, was actually reported in some of the newspapers. Now I'll move on to the next case. This is an older case. Perwananan Menteri Besar Kelantan Syarikat against Syarikat Perusahaan Maju Bina, 2016 case, also Court of Appeal. Now, this case mainly talks about the claims for direct loss and expense under clause 44 of the PWD form. And here the court essentially disagreed with the High Court, i.e. saying that not all, looking at this particular clause 44, not all loss and expense, not all delay events give rise to a right to claim for loss and expense. So you have to look at the clause very, very carefully. Only some clauses would give you a right to claim for loss and expense. And one of the things that the court also highlighted is that a notice of such claim must be made within 1 month from the occurrence of the event or circumstance. Together with the notice, the respondent must provide proof of such loss and expense, and the notice requirements have been construed to be strict requirements which must be met before a claim arises, as decided by this court in an earlier case. So what I would like to just sum up by saying is that be really familiar with the contract, comply with it, especially the notice periods and the timelines. If not, then you may actually lose the right to claim for certain things under the contract, for example, for extension of time. So I think that is all I wanted to say. Back to you, Mr. Chin.
Okay, thank you, Victoria. Later, I'll come back to you because I think I have some follow-up questions from your talk. All right, now I'll move on to Balan. Okay, Balan, my question is this. Notwithstanding the fact that contracting parties have done their best to avoid disputes, what practical tips can you give the parties once a dispute crystallizes?
Thank you, Mr. Chin. Very good evening to everyone. I have also, to answer your question, I thought I'll just give a quick preview of what are the potential claims that you can make. And then I'll move on to the practical tips as to what you need to cover yourselves when it comes to making a claim post termination or determination of the contract. I'm going to try to screen share. I hope I don't end up showing you all the first page only. Bear with me, sorry. Okay, I may end up getting the same thing. Are you only looking at my first page?
No.
You can see the whole screen.
No, I can't see the screen.
You can't see my slides.
No, I can't.
Would you mind trying sharing it as a window rather than sharing the screen?
Can, hold on. No one told me that when you practice law, you need to be IT savvy or so. Sorry. Hang on a
Next time, get your
second.
pupils to assist you. Ah, okay,
I
yes,
know.
now we can see it.
All
You can see
right.
the full screen?
Yeah.
Yes, thank you
Okay,
very much.
Excellent, thank you. All right, so yeah, I've prepared presentation slides, but I'm going to move pretty quickly, as quickly as I can. Okay, now I'm just going to firstly touch very briefly on the common grounds for termination. Obviously, it pegs on whether there is a material breach. Material breach can come from failure to regularly and diligently progress the works or prolonged non-payment for work done. It's not as straightforward as the moment there's a non-payment, you can terminate, but there are factors involved. And if it's a prolonged non-payment in the sense that there'll be a long gap where no payment has been made, that can be determined as a material breach, entitling you a contractor to terminate the contract. Inordinate delays with no prospects of completion within time are instances where your completion date is probably 15th of September and today is 10th and you are probably 50% progressing. There's no way you can complete the balance 50% in next 5 days and so. So that is an instance where inordinate delays can result in termination. And of course, the last one is the most common one, the insolvency of the contractor. Now, once there is a termination, of course, the rights and obligations of the parties are deemed discharged, save and except for in some of the contracts where there is a confidentiality information involved, then the duty of confidentiality remains, and then dispute resolution mechanism, of course. And of course, not to forget the contractor's right to claim for work done and the employer's right to impose LAD remain enforceable. Those are common things. Delay, the ambit. Okay, what are the ambit? What are the claims that you can make? Of course, the big chunk is the EOT, which is common. The next one, the loss and expense. Loss and expense, some of the examples there, as you can see in my pie chart, you have the prolongation and preliminaries, acceleration costs, financing charges, head office overheads are the examples of loss and expenses that you can claim. And then, of course, you can also claim as a final claim for work done, either certified or uncertified. Other claims, loss of profit. If you are challenging the termination, the validity of the termination, you can actually go for the loss of profit. Costs incurred due to termination also ties back to the challenge on the validity of the termination. Interest for late payment of certified and uncertified sums. If you look at PAM contract, for instance, it provides for an entitlement to claim for interest for late payment. So you can make a case for that. Now, there are various methods of dispute resolution. We all know SIPA adjudication, quite widely used lately. We also have arbitration. From my experience, almost all of the standard form contracts contain arbitration clause. So you have to arbitrate your disputes. And some bespoke contracts, they have litigation as the mechanism for dispute resolution. And I think as BICM has introduced, the most recent one is the expert determination is another mode that one can utilize, provided you come within the purview of BICM. Your dispute comes within the purview, or your dispute resolution clause deals with expert determination, or even if it's not in the contract, parties can consent to the use of expert determination. Now, common issues post-dispute termination, I think both Esther and Victoria has touched on it on some parts, but I'm going to quickly run through. The issues we're going to have is being caught by the CP, non-compliance with the CP, particularly in respect of the notice requirement. When you don't comply with the notice, when the contract is still subsisting, usually parties verbally will say, don't worry, we move on, do this and do that. When there is a termination and it ends up in court, then the notice requirement becomes an issue. Court will uphold the sanctity of the CP imposed in the contract. Quantification challenges, it ties back with the documents, the quality of your documents that you have. Of course, this will involve incurring cost and expense, because you need to get experts to come on board to help you with your cost, your quantum of your loss and expense. Causation and proof is also another element that through experts we will try to establish that the delay was caused by the employer's default and not the contractor's default. And then the proof, which deals with the contemporaneous documents that you have to produce. Now, the most common issue that I have always faced is the poor documentation. It's always a honeymoon for as long as parties are in talking terms. But the moment things go wrong, and when things go really wrong, to the extent that you are left with no choice but to terminate the contract, it comes down to the quality of your documents. The sequence of work or work coordination is one aspect. What sort of documentation do you have? Changing style will disrupt any potential claims. You know, every time there's a claim, client walks through my office and he asks for me to represent him. My first question is whether your project director or your project manager is still with you. And he says, oh, long left already, because I blamed him and I sacked him. And that is a big, big problem when you don't have a project director who can sit with the lawyers to explain on site what actually transpired. I don't think the clients who sit in the office will be in the better position than the project manager or project director, unless your documentation is impeccable, which, take it from me, 2/3 of the time it's not the case. No respect, proper documents in respect of delay and disruptions. Now, sometimes you put in a claim for EOT. The supporting documents are so sketchy because you just assume the architect knows what was going on. Of course, like in PAM, there are clauses which says that things which are well within the knowledge of the architect, you can still impute it. But as what Victoria said, at the end of the day, it still necessitates you to file an application for EOT. You cannot say the architect knew what was going on. So obviously, you should have considered under the relevant clauses to KIMI 2310 under PAM, for instance, that he can actually do a final assessment and give me time. That rarely happens. Verbal communication or change of decisions. When you have VOs, you have WhatsApp groups sometimes, but sometimes it's more verbal. People on site will say, no, change this, move the wall here, I want this to be changed, stuff like that. Nothing is documented. But when you want to file a claim, and then the lawyers asks you where the document, they say, I was only having a chat over coffee. That's very common. So it is, and this is not only in respect of small companies. Do not get it wrong. Big establishments also make the same mistake. Email communication, site meeting minutes. Site meeting minutes, I have come across many instances where you look at a site meeting minutes, it's basically a reproduction of the last 30 site minutes with the action taken changes once in a while. But then when you try to explain, when I ask them, why isn't the issue on site about the preparedness of the site not reflective in the minutes, they only say, no, the company will prepare and then they give it to us, we just countersign only, because I thought everybody knows. But when your documents doesn't reflect your complaint, you have an issue. So if I'm acting for the other side, it's as simple as me just saying, your complaint was never brought during a meeting. This is an afterthought because it's not captured in the minutes. I'm just going to give you this one decision. This relates to a slight departure from the usual doctrine of concurrent delay. But I think what is interesting is the observations made by the court in respect to the documents. The first point, this is what they said. Contemporary documents recording the delays throughout the project are a key part of any delay claim. Over-reliance on after the event programming analysis is not sufficient. So you can have your best experts, but if your documents is very shallow, you're going to have a very big problem. Ultimately, to succeed, parties require credible delay analysis, which must be supported by a contemporary record. You know, we all know when you're doing a delay analysis, there are 4 methods, the most recognized 4 methods, and the expert will pick the methods depending on the scarcity of the documents you have. When you don't have, if you have very good documentation, then there's one particular method that you can adopt. If your documents are not so great, then there's another method you adopt. And that itself becomes the issue of contention during the arbitration, which method to be used. One expert will say, I'm going to use TIA, and the other one says, I'm going to use the as-built. So where do we go from there? So those are the common issues that we always face. And that comes down to the contemporary record that you have. Second observation, given the large number of interface issues on construction projects, it can be difficult to predict during the course of the works which issues a court or arbitrator may later conclude were the causes of delay. This one, which causes the critical delay? Delay 1 or delay 2 when it's concurrent and all those things. Therefore, in the event that a contractor's activities are delayed by the employer, it must nevertheless continue with its works, so as to avoid any later argument of concurrent delay, which may or may not find favor with the judge. This one also ties back with instances where contractor on their own accord decides to slow down the work or suspend works, either by giving notice or not, when the contract doesn't give them such an entitlement. And then the question becomes, then obviously it will be followed by a possible termination by the employer on grounds of unlawful suspension or slowdown in work. Then the question of whether the termination is valid or not would hinge on whether you were right to suspend works in the first place. We all know there's no common law right to suspension. So that's a big issue that we got to grapple with. I think there are still 2 schools of thought, but the majority seems to favor that if the contract doesn't provide such a right, then you don't have a common law right for suspension. The third one, delay claims are fact intensive and rarely easy to resolve. So only when problem starts, then you're going to start grappling, going through the documents and all that. I had one instance where there was not less than 200 variation orders in a single contract, and there was so much documentation, and there was basically a document dumping by the client on our side, because even they don't know which are the ones relevant or not, and they basically said, you lawyers sort it out. And that's obviously inevitably will increase the cost that you're going to be paying to your lawyers, because going through the document is not going to be easy. Most of the time, they are the document masters. We expect the clients to assist us, but when there's a reversal of role, and that becomes tough. So moving on, I just want to wrap up to say the best practices, replicating or echoing what Victoria said. The communication has to be properly recorded. There must be good documentation. Your schedule planning comes back to the work program that Esther spoke about. When you come out with the work program, it needs to be sensible and practical. And just touching on that, Esther mentioned about the negotiation on the contract terms. I think, at least from my experience, 99% of the time, it's a case where the contractor is just being eager beaver to just secure the contract. And it is always the case where the employer will say, take it or leave it. Only very few occasions I've seen contractors who have put their foot down and say, I'm not going to agree to this short timeline. You give me a reasonable timeline, and they make a case by presenting a proper work program to justify, to say there's no way I can complete it. And I think that should be the way, not simply taking on and try to cut corners, and then you always assume that, which is true in a way, that every contract there will be a variation. It's never come across a case where start to finish, no variation, exactly how it was instructed initially, at least from my experience. So they just assume that, okay, there'll be variation, we can do this, we can get extension of time, they are my good friend and blah, 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 but never happens when it comes to a dispute. Training and tech adoption. There are many, even for work programs, there are many technologies or systems that you can adopt. Primavera, for instance, I think very useful. It gives you the exact stage at which you are, you can even work out whether it falls into the critical path and so on and so forth. Flexible payment terms. I think this ties back to the mechanism of the pyramid scheme where you have the main contractor, subcontractor, and all that, how the division of payment, some clarity on the payment terms. And then, of course, the supply chain diversity comes back to your material cost. I have had one instance where parties agreed for a 2-year contract. They locked in the material price, and there was an unexpected delay. Even to get the site possession, it took about 8 months. So by the time they're halfway through the project, the supplier then said, our contract has come to an end in terms of the locking in of the price. Now I'm going to go back to the market rate. What happens? What's your recourse? Those are quite difficult, because if it's not provided for under your contract, it's not contemplated, then you're going to have a problem. So those are the things that you need to look out for. And yes, as much as most of us are lawyers, but I think the legal routes should be the last resort, because once it becomes legal, you're left in the hands of the lawyers, and it's left in the hands of a third party who's the judge or arbitrator to decide. And of course, with assistance with the experts. That's all on my part. Thank you.
Okay, thank you. Right. Going back to what Victoria spoke just now, and also you, Balan, both of you mentioned about keeping proper records and the problems of poor documentation. Now, I think this is a practical problem which subcontractors or subcontractors, those small contractors, face when they don't even have enough manpower in their office to handle all these correspondences and documentations. Any suggestions on how they can overcome this problem?
Okay, I think there must be at least a dedicated person who is actually looking out for all the well, rather ensuring that the contract provisions are being followed. As otherwise, I mean, you're going to be left at the receiving end later on if things were to go south. And if most of the time these days, what we see is that when things do go south, then you can't locate letters, or sometimes the letters don't have the proper dates the dates could be wrong, or I think as what even Balan mentioned just now, the minutes of meetings is basically cut and paste from the previous meeting, and as I think lawyers, you cross-examine the witnesses, and then you say, okay, you look at the minutes, the last minutes has been confirmed as correct. So now you're saying something else, that surely cannot be correct, because, the minutes of meetings, those are the contemporaneous documents, so it's very hard to then, say, oh, no, but verbally, this was what happened, this was what I remembered, this was the conversation I had. But I mean, what I want to say is that you have to get somebody who to look at make sure that the contract is being followed. Otherwise, there really is. It's really hard to justify. At the end of the day, if this goes to court or if this goes to arbitration, the clauses are there. You sign on the dotted line. Why do you not follow it? You could have asked for extension of time. There is a procedure for it. Give a notice, or the contract may even say, okay, for if you're applying for certain types of delay events, like let's say, for example, inclement weather, the contract may even say, spell out what kind of documents do you need to show, to produce, to actually ask for extension of time because of inclement weather. For example, records from the meteorological authorities and things like that, or for maybe the last 5 years. So, or you may need to put in your site records to show, rain for, I don't know how many days and all that kind of thing. But if you don't have all those records and you didn't know you had to produce all of these, then when it comes to actually making that application, you may not even have those records. So, which is kind of ties back to what I said earlier about, being familiar with the contract. In fact, I wanted to add also that be familiar as well as read the contract, because you cannot assume that, oh, this contract, I'm going to apply PWD. I'm very familiar with the PWD form, or this is PAM contract. I'm very familiar with the PAM contract. But what if there are actually amendments in the contract? Because the PAM form and the PWD form, they're not written law. They are template contracts. So sometimes, for example, it may say, give a reasonable notice or right after the event. But what if it has been amended to say within 25 days? And you think, oh, it's just reasonable time, and I think 2 months is reasonable. So, I put in my notice after 2 months. So be very, very careful. And I think people, need to be aware that, if the case goes before, if a dispute happens, unfortunately, and it goes before an arbitrator, adjudicator, judge, contemporaneous documents are really, really important, and complying with the contract is also really important. Unless you have very, very good, very, very good reasons for it, but I would rather not go there. Yeah.
Okay.
I think just to add on to what Victoria said, I think one way that you can seriously consider is to engage some third-party contract administrators, or get a project management team to come in, depending on the size of your contract. I think most contracts allows some allowance for you to get a contract administrator. Contract administrator can also be a lawyer or a consultant, QS, or someone, just to oversee your compliance with the contractual provisions or requirements, so that at the very least the paperwork is intact. And I think depending on the size of the contract, as I was saying, it'll be cheaper, and there's a greater degree of certainty compared to you coming and knocking on the doors of the lawyers to ask them to help you when they can only do so much based on what they have before them. And bearing in mind, it is still down to the quality of the witnesses who's going to be in court, who's going to give evidence. It's up to the arbitrator to form an opinion as to which version he believes more than the other. So in short, it will be an unfortunate instance where you're leaving it in the hands of a third party to decide your commercial fate, when you could well deal with it while it's still within your control. So doing a contract administration or project management, it's something that you should seriously consider. so that at the very least, when things go wrong, it's not fault proof, but when things go wrong, at least you know documents are intact. Or alternatively, you engage someone within the company. All they do is contract administration or contract management. They focus solely on that compliance, CP, and whatever not, so that documentation is taken care of. Everything comes down to documentation, as Victoria rightly said. Your documents, it's not there. You can have 10 witnesses to speak about the same thing, but if it contradicts the contemporaneous documents, the court is entitled to disregard all their evidence, testimonies.
Okay, so that means that if there's any oral instructions on site, they should just scribble down on a piece of paper and either fax it over or email it over, right?
WhatsApp,
At least there's
I
some
think
proof.
WhatsApp will do.
Yeah, WhatsApp will do. Yep.
WhatsApp evidence is acceptable
True,
now.
true.
So I think
Yep.
you can just WhatsApp to say, hey, as spoken,
Yeah.
you know, I will carry out the changes. Something, you know.
Yeah.
Yeah.
Okay.
Actually, you have
It's
to be
quite
very
common.
careful. You have to be very careful with WhatsApp messages because it's so easy. So I've seen many cases where WhatsApp communication is adduced as evidence, is even adduced as evidencing an entire contract.
Yeah.
Yeah.
Yeah, contract can be formed through a WhatsApp.
Yeah, I think WhatsApp is,
Yeah.
it's not entirely safe, but I think it's quite commonly used nowadays. So
It is, yeah.
yeah, there were instances where courts have not been too happy with the WhatsApp evidence, but I think it depends on the issues that was before the court.
Yeah,
Okay.
I think
yeah.
just a little bit. I think after hearing from the esteemed advisors given by the lawyers, I think coming from an in-house counsel, I want to stress the importance of resources management. Like, although this is a construction industry, at the end of the day, it's about your product, the people, how good are the people, how competent they are, and the works they have. So more so, we go to legal when we have exhausted all the negotiation means. But if at day one, since day one, for the architects or consultants, you are very skeptical or very careful in selecting a good subcontractors or contractors who knows their stuff well, who will tell you on the face that, look, this contract duration doesn't work. Please appreciate those honest advisors and please reflect back to employer. That will really save a project. I saw a lot of delay issues because the parties are not honest with the situation. They know they cannot reach it, but they still sign the contract. So it is disastrous and very sad to see that parties plumbing money, but delay happened. And then at the end of the day, the lawyers who needs to manage the claims in court. So I think at the end of the day, I suggest to give more attention, more investment in good contractors or subcontractors or main contractors that will really save your project. Yeah, just to wrap it up.
But sometimes, right, Esther, the contractors who tender, I mean, they may have a good track record or something, but behind the scenes, they may be desperate to secure the contract, like Balan said just now, right? Because, I mean, competition is fierce. So if they don't read, they just blindly jump into it, then they're asking for trouble already, correct?
I think asking for trouble, it goes two ways. For the employer to accept it, for the main contractor to subject themselves to risk situation. That's fair play, that's market. But I still have some confidence and belief in good contract or project management where the consultant knew that that company is not competent at all. They should have bring it up. I'm sure we have ISO processes going through the tendering process and whatsoever. And for some of the PLC, they are very stringent when it comes to sourcing and resources management. So if that in place, it really saves a lot of issues. Like what Mr. Chin, you mentioned, yes, it happens, but those are the bad things which I think we can avoid and mitigate in the construction industry. So just a shout out to the construction industry. Let's do something sustainable for the projects. Yeah. Like if
Okay.
50 Cent couldn't build a 500 million project, it meant like that. That's the fact.
Yeah.
Accept it.
All right. Thanks, Esther. Okay. I got some additional questions. One of them is this: apart from the usual modes of dispute resolutions, for example, mediation and arbitration, what are your views about utilizing expert determination as a form of dispute resolution?
Sorry, Chen, can I just repeat that? Sorry.
Yeah. Apart from the usual modes of dispute resolution, like mediation and arbitration, what are your views about utilizing expert determination as a form of dispute resolution?
I have not used expert determination so far. So everything theoretical based on what I have read. I've gone through the rules recently. It says final and binding, but the enforcement, and it's not as good as an award. It cannot be equated as an arbitral award, if I understood it correctly. So it still comes down to the question of how are you going to enforce it?
Okay.
I don't think that there will be an enforceability issue if I understood it correctly. But it's cheaper, it's quicker. So once party agree, I think expert determination actually makes simplify things better. And you can kind of equate it, not the enforceability, but the mechanism akin to FIDIC DAB, sort of where you have an internal mechanism to resolve without affecting the progression of the contract. But unlike DAB, I think the question of enforceability is something that you may want to seriously consider. Because from what I understand, if you have an expert determination, I don't know whether it's called an award or a decision, then you have to enforce it by filing a claim in court. And then
I think that would be on technical issues. The expert would make a decision on technical issues, so that then it will speed up the process of the actual arbitration hearing.
Yeah, so it's more as an aid to an actual dispute resolution mechanism as opposed to a standalone mode of dispute. I'm familiar, I'm just purely based on what I've read on expert determination. I think just like CIPA, it has to face the test of time to see where we go with that. It took us 10 years and CIPA is still not settled in many aspects.
Yeah. All right. Okay. Another question I have for you. Do you know the, what do you call it? There are a lot of changes in scope of works during the construction period, right? Mostly it occurs, and that leads to changes in construction drawings, etc. Probably addition to material costs. Now, I want to ask all the panelists, in your experience, what advice can you give to contracting parties to try and limit the disputes arising from variation orders?
I can start first from the live contracts. Usually in the projects that Cornet typically take up, not the biggest challenge to have active discussion with the consultant, main contractors or employers to agree on AI, EI, architect instructions or engineer instructions or variation VO under the PAM. I feel that the construction industry is maturing in the sense where employer felt that it is a necessary instructions or under the good advice by the consultant or architect, not difficult to get an agreed quotation for VO, AI or EI. So based on my experience, we do have one or two projects where the consultant didn't take up their responsibility dealing with the situation, and there was this impasse. I also know that under the PAM contract, you still need to carry out work even if there's no agreed quotation on the VO. I realize that. But so far, I think my project team also doing a good job in getting agreed fee quote for the VO and then for them to carry out work. So that's one of the fundamentals to avoid issues VOs. Yeah.
Okay.
I think very briefly from my experience, I think most of the time there is some time sensitivity involved in respect of VOs. When VOs are being instructed, I don't think they will have the luxury of time saying that you put in the codes from 3 different sources and we'll compare and we will evaluate. Most of the time, from what I've come across, are instances where the employer will tell them this is VO, please carry out, but you put in a claim for us to evaluate whether you're entitled to more money or it can be squared off. So that gives rise to issues later on. That seems to be the practical issue that we have, that I've come across. But there were instances where VO was ordered much earlier and they were able to agree on the code before works were carried out, but probably 10-20% of the time. That's from my experience. So I think the practicality aspect needs to be considered, because VOs sometimes come at a time when there's a rapid progression and it has to be implemented straight away, and you don't have the luxury of time. So in those instances, you need to have some documents in place. It comes down to the quality of that documents. Everything comes down to the quality of documents.
Okay. All right.
So, I mean, yeah, I think maybe I would just add on from, I think most of it has been covered by Esther and Balan. But I think if, let's say, either party is not following the procedures in the contract, at least have a record saying, maybe from the contractor saying, okay, we received this instruction verbally from Mr. So-and-so of who, whether engineer, architect, or employers verbally, whatever it is, this is going to result in time and cost implications. And we will carry on with the instructions, but we reserve the right to claim, something along those lines. So at least there is something, or if there is already quotations, attach the quotation as well. We understand that this is urgent and we will comply with the instructions, but here is the estimate cost, something along those lines. So at least there is something. Otherwise, oh, this was verbally instructed by us or so-and-so and all that kind of thing. Later on, when there is a dispute, this Mr. So-and-so is nowhere to be found, or he says that, no, I don't remember giving you such an instruction. All sorts of things can happen. Yeah.
Okay. All right. Can I ask BChem if there's any questions from the participants?
We have a minute to go.
Hi, so from the chat box, I don't see any questions as of now, but to all the participants, if you have any question, here's your time. So you can choose to click the raise hand button, and then I'll call out your name, and then you can unmute yourself, and that's how it goes. But as for the chat box, I don't see any at the moment.
Okay. All right. Well, I have one question, which I think happens quite a lot. During the defect liability period, right? Probably say for 6 months. Now, we've noticed some contractors, they just say, okay, 6 months is a long time. I'll just put a skeleton crew there. 2 or 3 persons. They do the job, and the employer is like, come on, man, put more people. Now, the employer will probably try to ask the lawyers, will this fall under, what do you call it, failure to diligently proceed with works? What's your opinion on this?
I think for a contractor company, the responsibilities under the DLP is to rectify defects. So long it is done and achieved, defects were rectified and remedied accordingly under the contract, according to your specification and scope of works, there's no breach. And it's really up to the contractor to allocate its resources, which I think resources were priced in or make it clear during the tender process. That may be the case. So employer couldn't now say, I want more people, but for what? Like if the contractor managed to rectify all the defects accordingly, why you need more people? Unless it is stated clearly in the contracts, some of the bigger contracts, oil and gas projects, specification on 10 people to be on standby mode, okay, that's fine. If contract doesn't say that, I think contractor is at liberty to provide resources or not, so long he achieved the defect liability responsibilities under the contract. Yeah, that's how I see it. Yeah.
Okay.
If I may very quickly add, I think I mean, once you have your CPC and then you go into a DLP period, and their manpower is quite wafer thin, and things are not moving, the defect works are not moving as expected, I think employers can always give them notice to say, please finish it as soon as you can, and put them on notice to say, if you don't get it done within such a period, I'm going to put in more people to get it done, and I'm going to issue you a back charge. I think that may be a simpler way. To me, anything happens during the DLP period, at best gives rise to a back charge. You can't
Okay.
terminate the contract. Project has been
Yeah.
completed. Yeah.
True.
And there's usually there's usually also in the standard form contracts there's provision for certain notices to be given. If not, then there might be even a right to deduct from maybe a retention sum of a performance bond, that kind of thing. Yeah.
That's right. That's right.
Okay. Thank you very much. I don't think there are any questions from the participants.
Okay.
Yes, that is right, Mr. Chin.
Yeah. So if there's none, then I think I would like to thank all the speakers for today. Thank you for taking time and effort to attend and participate in this BicTok 31. I think I'll take away from this today is we must all keep proper records, right? And if not, you'll be at your peril.
Yeah, absolutely.
Okay. To all the participants, thank you very much for joining as well, and we'll see you at the next BicTok, number 32.